Good morning. The Local Government and Municipal Finance Committee will come to order. Madam Clerk, would you please take the roll?
Chair Fitzgerald.
Here.
Representatives Burns. Here. Shannon.
Present.
Breen. Present. Rogers.
Here.
Hill.
Here.
Hoskins.
Here.
Pies.
Present.
Zorn.
Here.
Paquette.
Here.
Mazat.
Here.
Bagol.
Here.
Preston.
Yep.
Mr. Chair, you have 13 members. You have a quorum.
Thank you, Madam Clerk. I need a motion to adopt the minutes from our previous meeting. That motion is made by Representative Pies, and seeing no objection, the minutes are approved. With that, we have three bills before us today. The first of which is House Bill 5203, which we heard testimony on at our previous meeting. This will, again, allow for the uncapping of the 1,000-hour cap for retirees returning to law enforcement offices, sheriff's offices. With that, we would like to bring this up for a vote today, unless there are any questions from the members. Seeing none, I need a motion to adopt House Bill, or to recommend House Bill 5203. That motion is made by Representative Breen. Madam Clerk, would you please call the roll?
Chair Fitzgerald.
Yes.
Representatives Burns.
Yes.
Shannon.
Yes.
Breen.
Aye.
Rogers.
Yes.
Hill.
Yes.
Hoskins.
Yes.
Pies.
Yes.
Zorn.
Yes.
Paquette.
Yes.
Mazat.
Yes.
Bagol.
Yes.
Preston.
Yes.
Mr. Chair, you have 13 yeas, 0 nays, 0 passes. House Bill 5203 is reported with recommendation.
The motion carries. Thank you very much. I did have one card to read in. I apologize. Not wishing to speak in support of the bill, Samantha Gibson from Michigan Association of Counties. All right. With that, we will move on now to Senate Bill 721, introduced by Senator Moss, regarding the Marketable Record Title Act. Unfortunately, Senator Moss cannot be here today, but we do have some folks here to speak to the bill. I do have Elizabeth, and I am so sorry, I do not have your last name legible, Crenshaw, in front of me. You can please come forward, and you can begin when you're ready. Again, this is a relatively technical bill. I am expecting to bring this up for a vote today due to the time-sensitive nature of this sunset extension. And so, Ms. Crenshaw, you can begin when you are ready.
Thank you, Mr. Chairman. I'm here on behalf of Senator Moss in his absence, and just wanted to give you a high-level overview of the bill and keep it kind of simple at the same time. So, Senate Bill 721, it's extend the definitive deadline to record marketable local record. The basis of this bill is to extend the sunset for requirements to preserve minimum interest more than 20 years old and real property interest over 40 years old. Stakeholders have been trying to extend the sunset since 2020 while they work on overall changes to the Act to reconcile conflicts and make compliance less onerous. And without this extension of the grace period, the deadline will create great expense, uncertainty, and risk that valuable property interests, including easements and restrictions and agreements to maintain roads and storm drains, may be lost unless property owners, their attorneys, and others create and record notices of claim and provide proper notice. Thank you.
Thank you, Ms. Crenshaw. And I recognize that this came through the Senate last month. It did come through unanimous as well out of both committee and off the floor. Am I correct?
That is correct.
Okay, thank you. This is the extension of that sunset, and I believe that it was made to reflect a September 2025 date. Am I correct?
That is correct.
Okay, thank you. Do we have any questions for Ms. Crenshaw? Representative Hill.
Thank you. Storm drains have been a big issue in my community with flooding that we have had, unfortunately, on a more frequent basis. Could you... I understand how often, so the question is, how often are these claims brought under this act for ownership or mineral rights? And it's okay if it's at a high level. I'm just trying to understand what this rule is for, and then I hear that you're trying to make it less onerous.
Correct. Yep. Can I also call up someone?
I was going to say, we
Yes.
do have some
I do
some
have
detailed subject matter experts as well who might be
Yes.
able to better answer that question here. So if we will, we'll put a pin in that question here and allow our next person testifying to speak to that. Ms. Crenshaw, I'm going to go ahead and then call up, yes, David Pearson with the Real Property Law section to the front here to provide your testimony and some background on the bill as well. And you may begin when you are ready as well.
Thank you very much. David Pearson on behalf of the Real Property Law section of the State Bar of Michigan. And I should advise you, this Real Property Law section is a voluntary organization of real property lawyers devoted to trying to make the law, real property law in particular, easier for everyone and make it apply more fairly. The basis and the genesis of the bill that you have today is from the 2019 amendments to the Marketable Record Title Act, which were proposed by the title insurance companies. They imposed new requirements in order to preserve mineral interests over 20 years old and other property interests over 40 years old. And the idea was to allow title insurance companies to insure over old interests that, frankly, no one had an interest in preserving, but in order to get rid of would have required very expensive and difficult litigation involving sometimes hundreds of property owners named as defendants. That was the idea, was to allow then redevelopment of those properties despite those old restrictions. In the Department of Be Careful What You Wish For, the effect also was on many other, just a host of other property interests. And as the practical effect of that was realized and lawyers started to work through what that would be, the Real Property Law section put together a committee to try to bring together all of the stakeholders in order to determine how better to work this out. That took time. And then, frankly, because of the complexity of the Marketable Record Title Act, frankly, getting a sponsor was difficult because whoever sponsored this wanted to have some understanding of what was the background. We have a bill. We have a sponsor, we believe, and our hope is to move that forward. The difficulty is that what the amendments did was allow a grace period for filing notices of claim with a deadline which is now March 29th of 2024. What we're looking for is the addition of time to allow the legislature to consider the changes that are proposed, and because once that becomes part of your process, we're quite sure there are other interests that will come forward which want to be part of this and give you the time to do that. If the extension doesn't happen, the difficulty is it's not easy to know what to file, when to file it, and frankly, all of the parties involved. In the case of subdivision restrictions, that involves hundreds of lots in subdivisions or adjacent developments. For commercial property owners, it's peculiar because it means not just doing a title search on your own property, but you've got to get title searches on all the properties around you in order to discover what is affected. To go ahead to the question on drains, for example, a storm drain on my property is of no use whatever if it doesn't continue through all of the other adjacent properties. There are any number of commercial developments, 60s, 70s, and 80s, where the adjacent property owners share parking, they share stormwater drainage, they share access roads. All of those, again, if they're over 40 years, would be affected by the 2019 amendments unless we can work through exemptions and the practical effect of knowing when and how to file those notices of claim. That's the reason for the extension. I'd be glad to hope to answer any questions that you have.
I'll follow up with Representative Hill to make sure your question was answered.
It's complicated. Yeah, I think what I basically hear is there's a fix has been developed. You're continuing to work on that.
Yes.
And this just gives us this 18-month time frame to bring that forward and potentially have a longer-term fix, is what I'm hearing.
Yes, and really what we're looking for is we assume that anything that happens in this session won't go into effect until March 29th, say, of next year. The additional 6 months is frankly what we discovered with the last amendments are the state's trying to figure out how they work and what you need to do for individual property owners in order to preserve those interests.
Okay, thank you.
And I can attest to the nature of the stakeholder engagement that has taken place on the development of this longer-term fix. I know that this has been continued to be scrutinized and negotiated, and so I appreciate your attention to this. I've had some awareness to that process moving forward, and so understanding that this is time is of the essence, right? We are in March of 2024 when this is going to come to an end, and so the extension is really important, again, to allow this body and the legislature as a whole to consider the longer-term fix as well. So we appreciate your willingness to provide that for us.
And we very much appreciate the actions that have already been taken and the willingness, we hope, to move it forward in time.
Thank you. Looking to the committee for any other follow-up questions for Mr. Pearson here. Okay. Thank you very much both for your testimony and for being here today. I do have one card to read in. Not wishing to speak in support of Senate Bill 721, Evie Sweeney, representing the International Council of Shopping Centers. With that, I need a motion to report Senate Bill 721 with recommendation. Representative Burns makes that motion. Madam Clerk, would you please call the roll?
Chair Fitzgerald.
Yes.
Representatives Burns.
Yes.
Shannon.
Yes.
Breen.
Aye.
Rogers.
Yes.
Hill.
Yes.
Hoskins.
Yes.
Pies.
Yes.
Zorn.
Pass.
Paquette.
Pass.
Bazat.
Pass.
Bagol.
Pass.
Preston.
Pass.
Mr. Chair, you have 8 yeas, 0 nays, 5 passes. Senate Bill 721 is reported with recommendation.
Motion carries. Thank you very much. With that now, we will move on to our final piece of the agenda here today, House Bill 5353. And with that, the committee will go at ease call of the chair.
The Committee on Local Government and Municipal Finance will come back to order. We have Representative Fitzgerald here to testify on House Bill 5353. And Rep, please go ahead with your testimony.
Thank you very much. Madam Vice Chair, members of the committee, thank you for the opportunity to hear testimony on House Bill 5353, otherwise known as the Headley Unfunded Mandates Act. This bill is a reintroduction of Senator McBroom's bill, Senate Bill 449 of 2022. That bill did pass out of committee, but was not given a full vote by the Assembly of the whole. But really, the genesis of this bill came from stakeholders who underscored that Public Act 101 of 1979, which governs state disbursements to local units of government, have been largely ignored. My bill would require the legislature going forward to appropriate and disperse each year sufficient funds to pay each local government the necessary cost of each state requirement under Article 9, Section 29 of the Michigan Constitution. Simply put, this legislation follows what is already in place in the Constitution. House Bill 5353 would specify that a local unit of government would not be obligated to provide a new activity or service or increased level of activity or service required by state law unless a fiscal note has been prepared and the state has appropriated the necessary funds to local units of government. This legislation would create a fiscal note process that would actually require the Senate Fiscal Agency and the House Fiscal Agency to conduct a review and to determine whether any new or increased level of activity or services was likely to be required by a local unit of government, by legislation, rule, or state agency regulation. Under House Bill 5353, boy, that's a mouthful, the Department of Treasury would be required to develop a standard account system to assist with the fiscal note process. This would also require DTMB to adjust the necessary funding to meet the state's funding responsibility under that Article 9, Section 29 of the Michigan Constitution each fiscal year. 5353 would prohibit the state from imposing a penalty on or withholding funds or imposing any other form of monetary sanction on a local unit of government for failing to comply with a state requirement under certain circumstances outlined in the bill. Additionally, it would require a local unit of government to account for funds it received under the bill separately to reflect I've lost my spot, I apologize, to reflect that state-specific requirement for which the funds were appropriated. So this bill would not prohibit the legislature from enacting state law. Again, this bill would not prohibit the legislature from enacting state laws that would provide for other forms of dedicated state aid, cost-sharing arrangements, or specific methods of making disbursements to a local unit of government for a cost incurred pursuant to state law enacted which the bill would be applied. So finally, and potentially most importantly, this would repeal Public Act 101 of 1979, which governs state disbursements to local units of government for costs required to administer or implement certain activities to services required of local units of government by the state. So the intention of this bill is to examine current process and the responsibility of the state to determine whether this can continue to be the status quo. With that, we have additional subject matter experts here to testify and would be willing to provide additional background and consideration for the committee. Thank you.
Thank you, Rep. The committee will now go at ease.
The committee will come to order. As promised by our previous speaker, we have people here today to provide additional testimony. First, I'd like to call forward Dennis Pollard from Seacrest Wardle to provide some additional information regarding the process that we're looking to review here within the state constitution and the responsibility of state government. Mr. Pollard, you can please feel free to make your way forward here and begin when you are ready. And we thank you very much for being here today to provide your expertise. If you don't mind, just hit that red button at the stem of the mic there, and you'll be set to go.
Right. I want to thank you for having me here today. I am an attorney. I've been representing public bodies, local units of government in terms of challenging the state's noncompliance with the Headley Amendment since 1980. I filed the first suit in May of 1980 and have since that time I represent presently 400 or 500 local units of government in various cases. In most cases, it's in litigation because the state won't come into compliance without some kind of court action. Let me start with a couple of real basic points. The purpose for the Section 29 of the Headley Amendment is expressed in Section 25 of the amendment, and it reads, "The state is prohibited from requiring any new or expanded activities by local governments without full state financing, from reducing the proportion of state spending in the form of aid to local governments, or from shifting tax burdens to local government." That really represents the underlying concept in each of the subsequent sections. The one that's the subject of the bill that's before you, and by the way, I meant to say that I'm here in support of this bill, states, the state is hereby prohibited from reducing the state finance proportion of the necessary costs of any existing activity or service required of units of local government by state law. A new activity or service, we're now 45 years later, so this is the one that's applicable. A new activity or service or an increase in the level of any activity or service beyond that required by existing law shall not be required by the legislature or any state agency of units of local government unless a state appropriation is made and dispersed to pay the unit of local government for any necessary increased costs. So the idea was, and this was an ongoing process, that the state would keep track of what they were requiring either through the legislature or through a state agency, which is important to note. It includes any of the various agencies that impose requirements on local units of government, unless there was an appropriation and a payment, and it's to be paid on a current basis. In other words, it isn't like you let it accumulate for years. This was supposed to be paid on a current basis. So here we are 45 years later, and what the record clearly reflects, and I don't think anybody, even at the state level that I've dealt with, denies it, the provisions of this amendment have been totally ignored. There is no, for example, let me give you a couple examples. There's a state law that would be replaced by bill if the House Bill 5353 becomes law. And that is the Headley implementing legislation adopted in 1979. It's PA 101, 1979. There's a section 5 of the act requires the legislature shall annually appropriate an amount sufficient to make disbursements to each local unit of government for the necessary costs of each state requirement pursuant to this act, if not otherwise excluded by this act. An initial disbursement shall be made in advance in accordance with a schedule of estimated payments established in each state requirement. The schedule of estimated payments shall provide that the initial advance disbursement will be made at least 30 days prior to the effective date of the state requirement, and secondly, the first disbursement in each subsequent fiscal year will be made no later than November 1. That has never happened. November 1. This was intending to be November 1 of 1980. None of this has happened. The other one that, and these were just cherry picking, I mean, there's several sections, none of which have been complied with. Section 7 said it requires the legislature shall establish joint rules to provide for a method of identifying whether or not legislative proposes a state requirement as described in this act. And then it talks in terms of the legislature shall establish joint rules to provide them for a method of estimating the amount of a necessary cost required to provide disbursements to a local unit of government for legislation identified to propose a state requirement as described in this act. Secondly, the estimate required by this section shall include the total amount estimated to make make disbursements to all local units of government for the necessary costs required to administer or implement a state requirement during the first 3 fiscal years of the legislation's operation. None of that happened. Here we are, 45 years later, this has never happened. We have nothing to identify what is added either to the original bill back in 1978. There was an attempt made in 1979-80 to try to determine what are the statutes that impose requirements on local units of government. It was never completed, and it never was officially reported by the Department of Management and Budget at that time. So the point is, the state initially, the legislature initially thought it important enough to adopt the PA 101, the 1979 legislation. And it frankly is well-constructed. I wouldn't be critical of it at all. But it's been ignored totally. I mean, think about that. We're a constitutional form of government. What could be more fundamental than following, very easily discerned requirements imposed by the people of Michigan? In that sense, the Headley Amendment was unique in that it was done by just the people, not initiated by the legislature or other governmental entities, the governor or what have you. So here you have a bona fide speaking of the people, passed appropriately a new amendment to the Constitution. And it's like it didn't even happen. So what we're hoping to do is we think that House Bill 5353 will correct the problem. The one thing that I was on a commission appointed by this legislature, by the Speaker of the House at the time, and I served from 2007 to 2009 on the Legislative Commission on statutory mandates. And we went through and documented all of this. And this is referred to, I think we've provided this to, I don't know if it's been distributed to you, but the report is there. And it makes it very clear, and I wasn't the only, there were 5 people on that commission, it makes it very clear what this noncompliance meant. And it just said, it didn't call it shameful, but it just said it's irresponsible to have the people speak as clearly as they did and then have it ignored. So we submit that this will correct it, and the reason we think it will correct it is the section that Representative Fitzgerald read to you about the that the local units of government will be relieved of responsibility to comply with a mandate going forward. This isn't retrospective. We accept that it'd be too huge a task at this point to go back and try to fix it. But going forward, they would be relieved of a responsibility to come into compliance with a mandate from a state agency or the legislature until there has been an appropriation and a payment for the service, which is exactly what's required in the amendment. So we're hopeful that you will give this consideration. This stands as a real blight on our Constitution and needs to be corrected, and it's long overdue.
Thank you, Mr. Pollard, for your testimony. I do have 2 questions specific to you. We do have others wishing to testify on this bill, and I believe would provide some insight as to how this is being felt at our local units of government, and so we'll bring them up next. But with that, I will hear from Representative Paquette.
Thank you, Mr. Chair. Appreciate your testimony. You've been around for a while, which I respect. And in terms of this with...
I had black hair then.
What's that?
My hair was black.
Oh, that's awesome. So in terms of, I guess, with McBroom's bill last term, why didn't it get across the finish line from your vantage point? What were the hiccups, or what was the problem? Why is this falling on deaf ears?
Well, partly there was quite a bit of activity with the pandemic, and that really absorbed a lot of the time that might have otherwise been spent passing it. That's the only explanation I can give you.
Yeah, and I think
just didn't hear from him.
I think it's important to recognize that this has gone through many decades of probably attention, but never been addressed. And while we have had the opportunity in past legislatures or in past administrations to look at this, I think that it's always good to have a review of our constitutional responsibilities and to make sure that we are being responsible to our local governments who continue to day in and day out serve each and every Michigander. And I think most specifically, I think that local units of government have that need that if we have a new or increased need for service, That's going to bite into potentially general fund balances. That's going to cut into how that money can be spent locally to effectively manage a local body. That is really, I think, what is at the crux here is how are Michiganders' tax dollars being spent? Is it to address the local need, or is it to meet continued state mandates here from the legislature? Representative Hill.
Thank you. I was previously a city commissioner for 4 years before coming here. This is my first time serving in the state legislature. I recognize that this has been in place, I hear, for approximately 40 years. 45. Who was in charge those previous years?
Who was in charge of the legislature? Well, it's been mainly, I think mainly Democratic, or I should say Republican, but it's back and forth.
And I think that recognizing again that this has been around for many, many decades, many administrations, many majorities. I think that we would like to put this in a nice and tidy box, but recognizing that there is a responsibility here today to continue this conversation is important. Representative Pies.
Thank you, Mr. Chair. Excuse me, I had to step out for a couple of minutes, so I may have missed something. I'm wondering if this would apply to something like ADA compliance, infrastructure. I know a firehouse in my district has to come up to ADA compliance for locker rooms in their fire department for women. And I'm also wondering if this would apply to something such as recent election laws that we have with the 9-day early voting. So I'm looking at larger picture items, I guess. Or would this apply to that? And it also sounds more like this is a matter of enforcement, since this has been on the books for so long.
Well, it doesn't apply on any federal requirements. This only applies to state legislation or state agency rules and regulations. And so you'd have to trace the origin of it. And in the case of a federal requirement being imposed on the state, which in turn then is imposed on local units, that wouldn't apply. The Headley Amendment doesn't apply in that case. So we're dealing with things that are required by state laws and administrative rules and regulations.
Sorry. So state law would be something like the election law? I was noticing here in the notes somewhere, now I can't find it, where you
Could be
were
election.
talking about federal requirements. I believe this is on page 2 of the fiscal analysis.
I haven't seen the
Okay.
analysis.
This would mean a federal law, excuse me, or other federal action with the force and effect of law that requires the state to take action or provide a service affecting a local unit. So essentially, that's the federal government saying the state needs to do that, and then it comes down
You're
to
correct.
the local government.
Correct.
So so it is federal law in some sense then.
Still needs a state law to
Yeah.
be required to be adhered to. Yes, that's correct. Final question for Mr. Pollard here before we move on and have our other folks here to testify. Representative Breen.
Thank you, Mr. Chair. Thank you for bringing your testimony here. Thank you, Chair Fitzgerald. Sorry, I still don't have my voice back entirely. Coming also from local government, as many of us have up here, we've been talking about revenue sharing for a long time. And looking at an analysis from the Michigan Municipal League, we're looking at from 2001 to 2018, diverted dollars are about $8.6 billion away from local governments. So I just want to make sure I'm understanding this correctly. This bill has this crazy, audacious idea that if we here in Lansing are going to tell local units of government to do something, mandate that they pay for something, we're actually going to have to give local units of government the tools to accomplish that mandated goal. Is that about right?
That is correct. Exactly.
I sense a question of the rhetorical nature.
I just want to make sure I've got a good understanding of this bill.
That is an exceptional question and a good observation, Representative. Thank you very much.
Thank you.
Mr. Pollard, thank you very much for your willingness to come and testify here today before the committee. You're free to step back from the table now as we bring up three others to testify together. So I have three cards, and we'll have them all approach together. Wishing to speak in support of the bill, Dina Bosworth from the Michigan Association of Counties. Wishing to speak in support of the bill, Jen Rigterink from the Michigan Municipal League. And wishing to speak in support of the bill, Judy Allen from the Michigan Townships Association. I guess to kick it off, we'll start with you, Ms. Bosworth, if you'd like to kick us off.
Wonderful. Thank you very much. Dina Bosworth, Michigan Association of Counties. House Bill 5353 is a reflection of a decades-long conversation that we've had. So you just heard from Mr. Pollard, and Mr. Pollard served on the Legislative Commission on Unfunded Mandates. That report was issued back in 2009. And since then, we have had versions of this legislation introduced over and over again. But take that back even further, like he said, this was a Headley Amendment adopted in 1978. And in 1978, the electorate in Michigan said local units of government need to provide services, of course, but any increase in demand and any increase in services or an increase in the services we're already providing or additional ones need to be paid for by the legislature. You see us up here in front of you all the time saying, yeah, this is not a bad idea. We support legislation and concept, but we're always saying you've got to pay for it. And we say that you have to pay for it because at the local level, we don't have the kind of revenue generating capacity that the state has. We don't have the ability to recover from financial downturns in the economy the way that the state does. And I'm sorry, not quite off topic, but similar. Back during the Great Recession, we saw taxable values in Michigan drop by about 18%. That devastated local budgets. But because of the Headley Amendment and then its interaction with Proposal A, we are very much limited in our recovery from that financial downturn. So we can, increase by 5% or the rate of inflation, whichever is less. All the way to 2017, we were still about 18% below where we were in 2007. So it's not that local units of government are against some of the great ideas that the legislature has, things that you want to implement, things that you want to change. We're there to be adaptable. It's the revenue that it takes that we don't have in order to accomplish all of that. So the legislation in front of you, want to applaud you, Mr. Chairman. We absolutely love it and support it. It sets up a process that is going to stop you and make you think before you pass legislation through your chamber. And that to us is extremely important. It says, wait a minute, we are going to put a real dollar figure on this. When you see bills that affect local units of government, more often than not, the fiscal agencies will say indeterminate financial impact. That tells you absolutely nothing. And it's not necessarily their fault. They may not have the time. They may not have the resources to gather the information. This legislation here says you need to come up with a number. You need to identify what those mandates are. You need to come up with a number, and then the legislature needs to be financially responsible for appropriating that out to local units and not just put it on the backs of the locals to do it. So with that, Michigan Association of Counties is 100% supportive of the legislation, and we thank you for bringing it forward.
I would like to just quickly interject because I would like to applaud our dedicated staff who work tirelessly at the House Fiscal Agency. There is a dollar sign in the fiscal analysis on this bill. So I would like to just highlight that because they are truly the a core component of this engine that keeps us running. So thank you for your observations as well. Go ahead, Ms. Allen.
Thank you, Mr. Chair, members of the committee. I appreciate it. Judy Allen, Michigan Townships Association. And we also are here today to testify in strong support for the chair's bill, House Bill 5353. As you've heard from previous speakers, that this goes back all the way to 1978. And we've had the legislature attempt to look at this for multiple times. But we very much support this bill because it does establish that requirement for a determination to be made. On a daily basis, I shouldn't say a daily, but on a regular basis, there's a lot of times, as Dina said, there's an indeterminate amount or in terms of the fiscal the impact to local units or of a piece of legislation going through. And a lot of times the legislature wants to do good state policy. But the question is, how does that policy impact us at the local level? As I sit here today, there's testimony going on in the committee room across the hall that would create a statewide policy. But the local units of government will have to bear the entire cost of that. Not this, well, the state will have a minimal, but large part of that, percentage of that is going to be at the local expense. And another example is, again, this is when you look at public policy, the legislature in 2013, when they passed the disabled veterans property tax exemption. Great policy, no disagreements with the policy or the intent. But they put that on the backs of local units of government. At the time, the estimate was maybe 12 million. It is, the most recent fiscal estimate is over $80 million to all local units of government in this state. So it's when the legislature wants to enact policy, as Dina said, not that we have a problem with the policy because we are adaptable. It is a lot of times good policy that needs to be made. It is just the state needs to pay for the policy that they want to implement. And to the representative's question about the election issues, I will just state when it is a constitutional amendment approved by the people, that would not fall under House Bill 5353.
Good afternoon, Jen Rigtrink with the Michigan Municipal League. Not to sound like a broken record, but for the third time, we are also in support of 5353 and really appreciate the time over the years that has gone into a bill like this and it being brought forward for committee today. I don't want to just repeat what some of my colleagues here have said, but that hold harmless, something that's going to actually require you to stop, and what it does this policy do in holding harmless those local units of government, putting a dollar figure to that and weighing the benefits of the policy and the costs, I think is huge. Again, a lot of it is very good policy. It's just easier to pass that knowing that let the locals figure it out. And you've heard many of us talk time and time again about how our locals are struggling. I was in a PROP subcommittee yesterday where Treasury was testifying about revenue sharing. And there was a little bit of excitement to say that the level is back to 2001. We're in 2024 with 2024 costs. Yet we're back in 2001 levels when it comes to looking at revenue sharing. So just having that predictability around what can we do and what is our dollar and what's the expectations on the cost of those services. So we would ask for your support on this bill and happy to answer any questions. Thank you.
Excuse me. I have a question for any or all three of you here. Now, recognizing that we have a need to address the financial components for local governments. My wonderment is, do you feel like there are or could be circumstances where the responsibility of a program or of extended resources would be where a shared financial responsibility could or would make sense? I ask because thinking about how local governments are formed, that there are responsibilities of those local governments to provide certain services, that maybe speaking to that and the responsibility of local government, that if we were, I'm just using as an example, if we were to require one firefighter per X number of constituents or those served by that body, are we not required to provide fire or public safety services? So is there a shared responsibility there that would make sense under which local governments have been formed?
Okay, and Judy, you might want to answer that too, or Jen. When the Legislative Commission on Unfunded Mandates did their report, they said that there is about $2.5 billion in services that are provided by local units of government that we can identify at no cost to the state of Michigan.
Based on the 2009 figure, correct?
2009 figure. And billions more that they could not necessarily put a dollar figure attached to it. Local units of government are responsible for providing the services that were in the Constitution and paying for it themselves prior to the Headley Amendment. So when I think about your question, I think of cost share, right? I think of maintenance of effort payments. And with that, our entire county government is riddled with maintenance of effort issues all over the place. So whether it's, our percentage of the public health department, our percentage of the court system, those are mandates that are put forth by the state that you are not necessarily required to pay for. They're not unfunded mandates. Any expansion, if you said, we want to create an indigent defense commission, and we want to have, indigent defense attorneys be paid more, all of those things, that would have been an unfunded mandate, even though we're still paying for the court system and you're not paying for any other, you're not paying for more than your share of that. We're still paying for part of it. So does that help answer your question? Like an increased level, new things.
Yeah.
We're probably still going to have to provide the baseline of it, but increasing it, we wouldn't. No.
It does. Thank you. Any other commentary? I just want to make sure that we're not cutting you off too early. All right. Looking to the committee, any questions here for those testifying here today? Representative Rogers.
Thank you for testifying today. Several questions. One is actually for the chair. So you mentioned the fiscal analysis and that there's a number in the bill. Pardon my ignorance, and I apologize if this is an oversight, but the only number I see in the bill is $250,000, which is the IT cost in Treasury.
There is a dollar sign.
So you're just being facetious.
I am being somewhat astute in my observations to the current fiscal analysis, yes.
Okay. And do you have any ballpark? So, I mean, in general, I'm supportive, of course, with preventing unfunded mandates, but we do need to have a big conversation about what this means for the state if we're taking on all of these costs. What billions of trillions of dollars does this represent?
So I'll speak to that because this is a prospective policy. This is not retrospective, but we are not talking about anything that is enforced today. That in prospective policy, we would be thinking about laws that may be passed in the 25 legislature or beyond that would require a financial commitment from the state to reimburse locals for their responsibility. In that sense, we would not be having maybe a determinate figure. Here, you might be able to say how many unfunded mandates have been passed since 1979 or since 2009 when that report was identified, but it would be for each policy that we bring forward that dollar amount would need to be identified more plainly in a fiscal analysis for local governments to understand the cost and the responsibility borne at at the local level. And so because of that, I would suspect that it's not necessarily, it would be, to your point, Ms. Bosworth, an indeterminate figure, because in each individual policy, that number would be identified, and thus the aggregate of that could not be identified based on today because we don't know what those policies will be. Just speaking plainly about the process, though, clearly anything that we're bringing forward as a legislature, we believe has merit and has need or is meeting the need of Michiganders across the board. But to have that figure provided, we don't have that crystal ball. We don't have that opportunity.
Thank you. That helps. And then the other piece I wondered about is throughout the bill, it talks about increased level of activity or service. So who determines that?
Would any of you like to take that, or would you like me to? The idea here is that if we were to say, we the state have mandated that all public parks, just pretend, I guess, is that maybe you can all tell me if this is a bad example, but all public parks are required to have 8 drinking stations at each and every public space, or I'll use a family example. Every single publicly operated building is required to have a changing table for families. That the state would actually be then required to pay for that use. If there was or pay for that policy. If there was an example where we are already providing something through a state mandate and we are now asking them to do 50% more of that, we would be paying for the additional 50% that we would mandate in new legislation.
But do you see where, like, I would guess that there would be a conflict and there would be an argument at some point between the local municipality and the state? So does that just go back to litigation? If that would.
Do you have any insight here?
I don't necessarily have insight on that. I will say that it's up to the fiscal agencies to determine if there is an increased level of service required or a new mandated service required. And it would be up to the departments to also seek that fiscal analysis on any rules that they plan to adopt prior to the full adoption or the implementation of them. I can see us arguing, for sure, that there might be things that the fiscal agencies didn't necessarily consider or cover. And I don't know if the legislation actually has a process for that laid out. In previous versions of the unfunded mandates legislation, there was a Court of Appeals process where locals could take the state to the Court of Appeals for a quick determination as to whether or not an unfunded mandate was passed. That is not included in this. I'm not necessarily saying that I recommend that or that I'm asking for that. It was just something that would sort of help alleviate maybe some of that conflict.
Thanks. I can continue offline with you, Chair. And then my last question is a technical one. So we're talking about local municipalities in general, I understand that, but what about authorities? So like airport authorities, are they covered under this or no?
I would need to check the definitions, but I believe that they are.
Okay.
Yes.
Thank you.
And I was just going to add, Representative, to your comment, is like there is a provision in the bill that talks about working with local units of government to get as cost estimates.
All right. Representative Azat.
Thank you, Mr. Chair. Good discussion, trying to follow along. The one thing that comes to mind is the unfunded property tax for veterans. That's $80 million. Are you trying to go back and recover that money? Or is it moving forward? And then the other part of it is, do we have attorneys now getting into litigation and lawsuits based on the 1979 or 1978 law? Are we creating a mess here, or are we trying to fix something?
I am going to provide them the opportunity to speak here, but I want to jump in because actually just before this committee, I was joined in my office by a representative from the American Legion with that same question. Because this is a prospective policy, that we are not looking to claw back any of these unfunded mandates as they currently stand, this is not intended to create a situation where that disabled veterans property tax exemption is under threat of being lost to our veteran community here in the state of Michigan. So I just want to reassure you of that is not the intent of this bill, and I do not believe that under the policy that would occur.
You know, I love that bill. I love the veterans bill, but I also agree with Judy on this one. It should have been funded. So I do agree with both sides of the issue here. I just wondered how are we trying to fix this moving? Are we going to create a mess going back, or is it going to be this point forward?
And I was just going to say, in response to what the chair indicated, that this is moving forward, it's prospective, and I was just using that as an example to say, here's the cost estimate, here's what has been incurred at the local level when the original cost estimate was so much lower. Yes.
I would like to add that this is about mandated services and things that we are going to, in the future, be required to do. This is not about the legislature taking away local revenue, which is, I think that's a distinction now. Would love to look at legislation that dealt with that as well, that prevented the legislature from doing anything as long as they understood how much they were taking away. But this is more about services, and it is prospective.
Seeing no other questions, I thank you very much for your willingness to come forward and testify today, and for your commentary about how this is affecting our local units of government. I have a few other additional cards to read in. Not wishing to speak in support of the bill, Scott Smith from the city of Wyoming. Not wishing to speak in support of the bill, Brenda Pilgrim from MASB. Not wishing to speak in support of the bill, David Rendles from Oakland Schools. Not wishing to speak in support of the bill, Mike Spence from SEMCOG. I want to thank members for their willingness to engage on this discussion. I think that, as indicated, this has been a wound that has continued to heal, scab over, get picked at, and has continued to really affect local units We need a pretty picture to be able to really grasp this. But this has been something that has festered for local governments for decades. We need to continue this discussion because I really do believe that we, as a legislature, have a responsibility to understand those indeterminate financial impacts to our local units across the board with whatever policy that we put forward. You know, it was highlighted that the indeterminate factor of this does not allow for good planning and responsible management of Michiganders' resources to be put into the right place at the right time. I think that this is a conversation that will continue, and I really appreciate the commentary and the testimony today that I think helped to underscore some of these really important issues facing our state. So with that, with no members absent and no further business before this committee, the committee will stand adjourned.